Right now, all across the country, families are being told the exact same thing by a nursing home admissions office, or sometimes by a well meaning friend. Spend it down, give it away. Watch your savings disappear into a monthly bill before Medicaid will help with a single dollar. Here's what almost nobody tells them: they didn't have to. If you're 65 or older with more than $2,000 in a bank account, Medicaid won't cover your long term care, not until that number comes down. That's the real asset limit in most states right now. But there are specific places that exact same money can go where it simply stops counting. Not eventually, not after a 5-year wait. Permanently, the moment it's set up correctly. I'm going to walk you through 3 of them, what they're called, roughly how much each one can protect, and the one phone call or signature that makes each one work. Here's why this is worth 9 minutes of your time. Nursing home care now runs well over $9,000 a month in most states. Medicaid is the program that eventually picks up that bill, but only once your countable assets sit at or near that $2,000 line. These 3 accounts don't lower that $2,000 number. What they do is change which of your dollars Medicaid is even allowed to count toward it in the first place. That distinction is everything, and it's exactly what gets lost between a nursing home admissions office, a financial advisor who's never specialized in this, and a Medicaid caseworker whose actual job is just to check the rules as they stand the day you apply, not to walk you through how to plan around them ahead of time. That's the gap this video fills. The fastest one to set up is the Irrevocable Funeral Trust. This is money placed through a funeral home into a trust that covers your funeral and burial costs when you pass. The word that matters here is irrevocable. Once it's signed, you cannot cancel it or get the money back under any circumstances. And because of that, Medicaid stops counting it as your asset the same day you sign. Most states cap this somewhere between $10,000 and $15,000, though a few allow more. Here's the part people miss. This is completely different from just opening a savings account and labeling it funeral fund. A regular savings account is still your money. You could still withdraw it and spend it on anything, so Medicaid still counts it. Only a true irrevocable trust or contract removes it from the calculation. Picture a widow with $9,000 sitting in savings $7,000 over her state's limit. She assumes her only choices are gifting it to her daughter and waiting 5 years, or spending it on things she doesn't need. Instead, she walks into a funeral home, signs an irrevocable pre-need contract for that exact amount, and by the next morning, her countable assets sit at 0. Her funeral, which would have cost that same money eventually anyway, is already paid for. Action step. Ask the funeral home specifically for an irrevocable funeral, trust, or pre-need contract, not a revocable one, because the exact wording determines whether Medicaid honors it. Request the written itemized statement and confirm your state's specific dollar cap before signing anything. That first account solves the problem of being a few $1,000s over the limit, but some people aren't a few thousand over, they're sitting on $40,000, $60,000, sometimes well over $100,000 in a CD or brokerage account. A funeral trust can't absorb that much. This account can. Here's how it works. You exchange a lump sum of cash in full for an insurance contract that pays you back in equal fixed monthly payments. For Medicaid to actually treat this as exempt, the annuity has to be irrevocable, non-transferable, payout within your own life expectancy using Social Security's actuarial tables, not a longer stretch a salesperson prefers, and name your state Medicaid agency as the beneficiary for any remaining balance if you pass away early. Because you're receiving full value back as guaranteed monthly income, It's not treated as a gift, so it doesn't trigger the 5-year look back the way handing that same money to your kids would. This matters even more for married couples. If a healthy spouse is staying at home while the other goes into care, an annuity in the healthy spouse's name can convert savings above the already protected limit into a monthly income stream that spouse simply keeps. Picture a retired postal worker with $40,000 in a CD, putting him $50,000 over his state's limit. He assumes gifting it to his kids and waiting 5 years is the only option. Instead, a properly structured annuity converts that $40,000 into a monthly check, and the lump sum itself stops counting as an asset that same week, not 5 years later. Action step: contact a certified Medicaid planner or elder law attorney, specifically not a general insurance office, and ask for an annuity that is irrevocable, non assignable, and actuarially sound, with the state named as remainder beneficiary. The exact wording on that contract is what determines whether it actually works. The third one can protect an entire 6-figure retirement account, sometimes with a single phone call, but only in certain states. This applies to a traditional IRA, 401k, 403b, or similar account. In a number of states, including Florida, Georgia, and New York, once that account starts paying out regular monthly distributions, the account balance itself stops counting as an asset entirely. Only the monthly payment counts as income from that point forward. In other states like Arizona, Missouri, and Pennsylvania, the full balance still counts even after distributions begin. There's no federal rule here. Each state decided independently, which is exactly why a financial advisor in one state can be confidently wrong about how this works in another. One important exception: a Roth IRA doesn't have required distributions at any age, so it generally can't be put into payout status this way, and most states still count it as a full asset regardless. Picture a retired teacher in Florida with $180,000 in a 401k rolled over decades ago on paper. That account alone disqualifies her completely. She calls the plan administrator, sets up a single recurring monthly distribution, and from that moment forward, the same $180,000 stops counting as her asset permanently, while she keeps every dollar of it still growing, still hers. Action step: call your plan administrator and ask them to set up a recurring monthly distribution. Then call your state Medicaid office or a certified Medicaid planner and confirm by name whether your specific state exempts retirement accounts in payout status, because roughly half of all states don't. And assuming yours does without checking is the single most common mistake families make with this strategy. Here's what all three have in common, and it matters. None of these are loopholes waiting to be closed. They're written directly into Medicaid's own rules, the same way the home you live in or the car in your driveway is already exempt. This is also genuinely different from a Medicaid asset protection trust, which can shield assets permanently too, but only if it's set up a full 5 years before you need care, because gifting money into that kind of trust does trigger the look back penalty. These three accounts work because they're structured as a purchase of equal value or a change in account status, never a gift. That distinction is exactly what Medicaid cares about. A Medicaid caseworker's job is to check whether you qualify under the rules as they stand the day you apply, not to walk you through every legal way to restructure your assets beforehand. That's the entire gap this video exists to close. If you know someone caring for a parent who's already been told to spend that parent's life savings down to $2,000 before Medicaid helps with anything, one conversation before that spend down happens, instead of after, can be the difference between protecting real money and losing it for good. Send them this video today. I'll see you in the next one.